The platform recognizes that women face numerous challenges in their personal and professional lives, including health issues, discrimination, and limited access to resources. As a result, Wings is committed to providing a safe and inclusive space where women can seek support, guidance, and mentorship from our members. The range of services offered by Wings members reflects the diverse expertise and experience of its membership. We had initiated the social cause because we at Wings believe that if Almighty has blessed you with some kind of knowledge, expertise, or some form of experiences, it is not to keep it for yourself or for your family, but it's to give back to the society. Because giving back to society is not a choice, it's a responsibility. That's how Wings has been founded. Through this multidisciplinary approach, Wings seeks to address the complex and interconnected challenges faced by women with a focus on promoting their overall well-being. By bringing together professionals from all walks of life, Wings provides a unique and valuable resource for women seeking support and empowerment. Today marks an important milestone in the journey of Wings, as we take a step forward in our mission to empower women and bring about a positive change in society. As we gather here today, we are reminded of the crucial role that legal advocacy plays in promoting the rights and freedom of women. We believe that every woman has a right to live a life free from violence, discrimination, and injustice. Through various programs and initiatives of State Legal Cell of Wings, we aim to create a supportive environment where women can thrive both professionally and personally by gaining access to our legal resources, seeking guidance, and asserting their rights. We are honored and blessed to have with us eminent guests whose thoughts and deeds align with our mission. We are immensely grateful to our esteemed guests for having graciously accepted our invitation and for their support and guidance they express as we embark on this new chapter in our journey. Their presence today is a testament to their commitment to women's rights and justice. We look forward to working closely with them to create a better future for women in our society. Honorable Mr. Justice A. Muhammad Mustaq, it's an honor and a privilege to welcome you today to this event, sir. Your presence among us is a source of inspiration and motivation for all of us. Your reputation precedes you as a socially committed person whose tireless efforts have brought about positive changes in the lives of countless people. Your dedication to upholding justice and promoting social equality has earned you widespread respect and admiration. Your commitment to the cause of justice is especially significant in today's world, where the fight for fairness and justice continues to be an ongoing struggle. Your unwavering commitment towards social cause serves as a shining example to all of us. We are deeply honored to have you here, sir, as a guest today, as your presence and work will undoubtedly inspire us to continue striving for a more just and equitable society. On behalf of Wings and everyone gathered here today, I would like to extend a warm welcome to you. Welcome, sir, and thank you for joining us today. Honorable Dr. Justice Kausar Edapagar, it's my great pleasure and privilege to welcome you today, sir. As an authority on the topic of personal law, your vast knowledge and experience have earned you a reputation as one of the most respected legal minds around us. Your expertise on this topic is particularly significant in today's world, where the rights of individuals are often under threat. We are grateful to have the opportunity to learn from your experiences and insights, and we look forward to hearing your words of wisdom. Your presence and presentation will undoubtedly enlighten us to apply the knowledge we gain from you in the relevant areas of legal aspects we would need to handle. I'm glad to welcome you to this event, sir, and thank you for gracing us with your presence today. Welcome, sir. We're honored to have you here. Advocate Parvati Menon, I'm so excited to have you here with us today, ma'am. Your presence among us is something that we at Wings cherish, and it's an honor to have you here. I can't help but say you're one of the most active and dynamic personalities I've ever met. Your enthusiasm and passion for social work are truly inspiring, and your dedication to making a positive impact on society is something that I hold very close to my heart. Your efforts towards empowering women and promoting gender equality are commendable, and they have impacted the lives of many individuals. Your passion for social causes and your commitment to serving the community are qualities that I deeply admire and respect, and I'm fortunate to know you personally. Today, we are all looking forward to hearing your thoughts and insights on how we can work together to create a better future for all. Your enthusiasm towards social causes are contagious, just like your smile, and I have no doubt that we will all leave here feeling enlightened. I welcome you wholeheartedly for our program, and thank you for being here with us today. You are a true asset to the community, and we are grateful for your presence and participation. Welcome, ma'am. Advocate Farida Ansari, my partner in solving crimes or rather problems. It's been a pleasure working with you till date, and I'm sure together we'll take it forward with the same enthusiasm, if not more. The diligence and dedication you have always shown towards rendering your services to society is something we should all imbibe. I understand that you, along with our coordinators, Advocate Safia Khan and Advocate Rahna Shakur, and rest of our wings members have invested quite an amount of time and efforts in materializing this legal cell of wings, and I deeply acknowledge and highly appreciate it. I'm sure with your leadership and guidance, we will go a long way, God willing. It's my pleasure to welcome you and our entire Wings team here. I'm glad that we are crossing yet another milestone at Wings, all praise to the Almighty. And lawyers, law students, NGOs, social workers, and all of its workers in here, you play a crucial role in shaping our society and upholding the rule of law. This event is an opportunity for us to come together and celebrate the launch of this new initiative. We hope that it will serve as a platform for learning, networking, and collaboration, and that it will contribute towards creating a more just and equitable society for all. I welcome you all to this gracious occasion, and thank you for marking your presence today. We hope that you enjoy the event and have enough takeaways to apply in your work and life. So get ready to spread your wings and soar to new heights of legal brilliance. Happy listening, and thank you once again, Moira. Together we achieve more. Thank you.
Thank you, Maya. Honorable Justice Mohammed Mushtaq needs no introduction. So without further ado, it's my honor to invite Honorable Justice Mohammed Mushtaq to inaugurate the State Legal Cell of Wings.
Thank you for inviting me to this program to inaugurate Legal Cell of Wings. My brother, esteemed Professor Pavadi Menon, Farita, Senior Advocate Pranka, and Shafiq, and all other lawyers and friends. And the Bhagavad is present to make a lot of difference. Well, it's very ironic when me, Professor, and Mahnas share dais. When we were budding lawyers with my father, myself, and Kausar, Mahnas was a school-going child in the next neighborhood, just opposite my house. So today we all came from Kannur to address you all people in Ernakulam. That's something to be proud of. Wings, I know since we formed VRC, I came to know about Wings. And we have a couple of interactions. We had a couple of visits to jail and Trishur, Farida was there, Kannur and Trivandrum. So the kind of contribution they're making, kind of impact they are making the life of others, it's immense. Well, they're predominantly been group, I believe it belongs to Muslim community. Of course, they extend their service to others as well. But they have obvious reason that there are a lot of issues the Muslim community is facing, especially the women, and they need to champion the causes of the Muslim community particularly because of social issues they face, cultural issues they face. When I talk about this community, being a member of the community, I also sometimes feel, identify myself with some causes they have. A couple of months back, or last year, a lady from Kochi wrote to me, her name is Swaradi. She's a hairdresser herself. She was divorced by her husband, an auto driver, and he married easily and another woman. And he's roaming around Kochi. This poor lady went to family court and obtained order. She could not execute the order. She always roams around the family court corridors. No way, no quasi steps. Many months and years passed. Around, I think, 3 or 4 years passed. Nothing happened. She wrote frantically to me. I don't know how she come to know about I'm dealing with the family court. So she wrote to me. So my secretary, meaning, contacted her and then said that we will assure whatever we can do that. So I asked High Court Legal Service, of which I'm the chairman. We asked Leela to take care of her case. Now, when she came before the court, life was good before her. She has no house to stay. She's now compelled to stay with her father and parents. There are many people, there are only one room and one latrine or something. No other place for us, 4 children. And one child is studying in Malappuram, and what is the supporting income is 6,000 she earns as some I believe as a feeding stitching or something in the 6 year, and her father wants to drive her out from her house. This Sorabi you can find in every place in the Kerala. Every family court, we walk into every family court, every magistrate's court, wherever you go, you find the Sorabis. There are thousands of Sorabis around us. What is that? What has happened? This is a particular issue with the particular government. Because of the power given to extrajudicial divorce, men misuse of those powers. And some community leaders are scared about it because they say the law. Law permits for divorce. So then she has been divorced as per the law. Yes, look at the law, yes, plain meaning is yes. The man would be justified by this people. But is it really justice for them? Is the law is bereft of justice? I think that's where we need to follow. In the Holy Quran and Hadith, everywhere it is quoted, the fairness is the root of the justice. What is the fairness? A kind of treatment which contextually demands. But what does fairness implies? Where is the fairness? Where is the justice for these kind of problems? When I was practicing in Kannur, of course, most of the cases, the typical cases are handled by counsel and other lawyer in my office, father's office. I used to see that. This kind of setup is across the corridors of the magistrate's court. Then they're queuing up on the court for veranda for getting 100 rupees or 50 rupees, and that will be given in installments. Where are the price of these women? Who they are accountable? I think this is high time where there should be a reaction from the community itself to such kind of approach. If extrajudicial powers granted to men or women, that has to be exercised for justification. You can't overlook the responsibilities attached to your faith or obligation. That your faith and just act according to the law. Law doesn't mean that a person who will be affected or impacted should not be given justice. There are many such instances happening in the law. Whatever form, the community is not aware of it. These people who are dealing with this cause of scholars who have no knowledge in the law, in the sense they know the letters of the law, but not in the jurisprudence of the law which governs the idea of justice system that governs the philosophy of such law. Time for us, the women in themselves have come forward, and that's the most appreciated aspect of this. There is a case where it's called during the period of Umar, the ruler who succeeded the Prophet. It's called a donkey's case, where in normal inheritance in Islam it prescribed the ratio of 2:1. That means men will take 2 and half shares will be taken by women. But that 2 share in 1 share is given to the women, not merely the letters of law, because men have attached with more onerous obligations and responsibility. That is exactly the reason they are given more share. It is not because at that time no law permits the women to get inheritance right, but Islam provides some solution for them. But now the men look at part of the inheritance right and they take 2 share and deny the women other share. In the 2 letters of law, yes, you find it. But a case came before the woman who has to adjust the foster brothers who inherit her or not. And he ordered for equitable distribution because he felt that there is a great injustice is happening. So, idea of justice, idea of fairness cannot remain aloof when we interpret the law. Law can't be interpreted in a particular manner on a literal sense. It has to be aligned with idea of justice, idea of fairness. That is so rooted in Islam. When Prophet was approached by a person saying that he wants to give the property to one of his child, he said, you can't. If there are more children, you can't. Because there should be an egalitarian concept in the matter of distribution. You cannot do that unless you give to a child. You cannot choose between them. But today we follow the law in the literal sense and deny the justice. And women are most vulnerable in these circumstances. So time has come to respond and react and empower those who are otherwise vulnerable to these circumstances. So Wing's role is not only in educating or taking up legal, legal cases involved in legal cases, but rather should focus on educating the people and to empower them. The justice should prevail, and that should prevail along with the law, and law can't prevail without justice. So this is where I formally inaugurate this function. I had to rush to another meeting at 5 o'clock. Thank you one and all. Thank you.
Thank you, sir, for your unwavering support to the cause of justice. Please accept this humble gift from our President, Ms. Meena Sashta, as a token of appreciation. Thank you, Meena.
Thank you, sir.
Every couple who enter into the institution of marriage hope to live happily ever after until they stop being happy. Society is enlightened enough to accept that divorces too are made in heaven. We now use this opportunity to examine the legal dissolution of matrimonial union between a man and a woman, the various divorce laws in India. Kindly note that depending on the availability of time, we have planned a short question and answer session, which we hope the attendees would put to good use. Hello? Sorry. So kindly pay special attention to the next part of the program. We could not have found a person better qualified to speak on the subject than Honorable Dr. Justice Kausar Ernakulam. Sir, we are sincerely grateful for accepting our invitation to talk on the subject.
Thank you. At the outset, I must congratulate Wings for this great initiative. In fact, I am asked to speak on the topic specifically Muslim person group. I think Parvati Menon will be dealing the other person groups. The subject is very vast. Time allotted is only 10 minutes. Let me see. Secularism is a concept enshrined in the preamble of our Constitution. It is considered as one of the philosophical foundations of Indian polity. Still, various pursuits administered in our country are not secular in nature. Applicability of personal laws depends solely on religion. As all of you know, each community is governed by distinct personal laws. There are various provisions in the Indian Constitution that are specified for gender equality. The preamble of our Constitution resolves to secure justice, liberty, equality, and dignity of all. The Constitution guarantees equality as a fundamental right. Article 14. Article 14 speaks about equality before law and equal protection of laws. Article 15 talks about non-discrimination on the ground of only of caste, religion, sex, race, and place of birth, etc. After the introduction. Thus, the idea of equality and non-discrimination is this. Okay. the idea of equality and non-discrimination on the ground of caste, religion, sex, etc. is strongly emphasized in the Constitution itself. It has been argued from many quarters that though we talk about equality of all genders, but sadly when it comes to personal laws or the family laws, it appears to be far from realism. And for long it is also argued from many quarters that the protection guaranteed at Article 14 and 15 of the Constitution remain only at the level of theory, as various religious personal laws in our country and followed by different communities deny equality to women in personal matters, or rather it is discriminatory towards women. There is another strong argument from those who are There is also argument from those who are claiming for gender neutral legislation that most of the recent family laws or laws related to women, such as Domestic Violence Act, are gender biased towards men and favoring women. We know that Indian laws are substantially binary in nature, recognizing only two sexes, male and female genders. But recently, as you know, another group has come up, transgenders. The apex court in the case of NALSA versus Union of India declared transgender individuals distinct from binary genders as the third gender under the Indian Constitution. These transgender people face unique issues in the context of application of personal laws, marriage, parentage, custody, adoption, and divorce to the domestic law. Which of the personal law would be applicable to them? Still in darkness. And also these transgender people regularly face transphobic harassment. So all these genders, male, female, and third gender, face gender related issues in the context of applicability of personal laws. There are arguments from different corners that all personal laws are discriminatory to each other, and personal laws governing Hindus, Christians, Muslims, Parsis, etc. are at significant variance and discriminatory to one another. So my topic of discussion today is Muslim personal law, particularly marriage and divorce. So before we deal with in detail, let us have a basic idea about what the personal law is and how is it recognized and administered in our country. As I already stated, the applicability of personal law depends solely on religion. Each community is governed by distinct personal laws. Nowhere the term personal law has been defined. But a personal law can simply be described as laws and customs as to family relations, family property, and succession. Of course, waqf and religious endowments are also part of it. During the British regime, all religious communities, including Muslims, were allowed to follow their personal laws. And permission to follow personal laws assumed statutory recognition for the first time in the Government of India Act 1950 and later in the Government of India Act 1935. And in 1937, the British Imperial Legislature assured Muslim personal law to Muslims by enacting Muslim Personal Law Shariat Application Act, popularly known as Shariat Act. The Indian Constitution, after the Constitution came into force, it recognized the existence of various personal laws in operation in our country, when the Constitution was enacted and adopted. And such recognition is apparent from Article 372(1), Entry 5 is 3 of the 7th schedule, read with Article 246(2), and of course Article 44 and Article 25. Thus, the personal laws of various religious denominations such as Muslims, Hindus, Christians, Parsis, etc. are recognized, administered and enforced in the backing of the Constitution and other statutes like Sharia Act. So far as the personal laws of Hindus, Christians and Parsis are concerned, their personal laws are fully codified. State actions. Hindus, Buddhists, Jains and Sikhs are governed by Hindu Marriage Act 1955, Hindu Succession Act 1956. And Christians are governed by the Christian Marriage Act of 1872, Indian Divorce Act 1869, and Parsis are governed by the Parsi Marriage and Divorce Act 1936. But so far as the Muslims are concerned, they are predominantly governed by uncodified Muslim personal laws. Section 2 of the Shariat application only says that in questions regarding marriage, divorce, intestate, succession, gift, etc., in case where parties are Muslims, the Muslim personal law shall apply. It is of course uncodified. Of course, there are few codified statutes like 1939 Act, Dissolution of Muslim Marriage 1939 Act, 1986 that Post Divorce Compensation Act and Waqf Act, and reason that Talaq Act. There is a popular belief, and in practical scenario, it is more or less true, as Justice Mustaq has given few examples, that the Muslim personal law practiced in our country is patriarchally harsh towards women and denies them sexual and economic freedom. The major criticism is leveled against law relating to talaq, polygamy and interstate succession. The criticism is that Muslim man is given unbridled power to divorce his wife by pronouncement of talaq at his whims and fancies. Similarly, Muslim male is given power to have as many as 4 wives at the same time the Muslim woman can have only one husband at a time. Similarly, in the matter of interstate succession, predeceased son doesn't get any right over the property when other children are alive, and the male get double share that of the female. These are the major 3 criticisms leveled. But at the same time, one cannot deny the fact that it was a Muslim law which recognized various women's rights in so many areas for the first time. Under Muslim marriage, under the Muslim law, marriage is both a civil contract and religious right. Contractual marriage was provided for the purpose of defining better scope for women's rights. The bridal price that was prevalent in the tribal Arabia was converted to mahar. It is a novel feature of Muslim personal law. Muslim matrimony will deal with it later on, mahar. And the indissolubility of marriage has been diluted. And divorce by mutual consent, Mubarak, based on breakdown theory, was introduced for the first time in Muslim law. And Muslim law was the first legal system in the world to grant women's right of inheritance. Till the codification of Hindu law 1955 and 1956, Hindu women did not enjoy equal rights along with Hindu women. And in an era of unlimited polygamy, it was limited to 4. However, it is a fact that more than 1,600 years have been passed since these laws came into force, and since then women have surged forward and occupied equal status with men and in this modern age. How far these laws would withstand the scrutiny of the concept of gender justice and equality clause enshrined in our constitution is a matter of opening debate. There is a cry for the need of a uniform civil code from various corners, including various judicial pronouncements by apex court, or at least for the codification of Muslim. The demand for the codification is emerging nowadays from within the community itself. With this preliminary observation, I will move to my specific topic, marriage and divorce. See the connected chemical.
ഇവിടെയാണ് അതിന്റെ കോട്ട് വെക്കുന്നത്.
And then you go to അത് ഇതിൽ പറയാം, ഇത് കണക്ട് ചെയ്യും, അല്ലെങ്കിൽ എനിക്ക് തിരിഞ്ഞ് നോക്കേണ്ടത് ഫ്രണ്ടിൽ സ്ക്രീനിൻ്റെ കുഴപ്പം.
Should we switch off the light? Is it visible there?
I think we'll switch off these two.
Do you need us to switch off the light? It's visible, right? Should be.
കാണുന്നുണ്ടോ? Okay. See, there is a popular misconception that Muslim marriage is purely a contract. സാധാരണ എല്ലാവരും പറയാറുണ്ട്, കാശ് കൊടുത്തിട്ട് it's merely a contract, so at any time you can break the contract. It's only a general misconception. Of course, the marriage under Muslim law is not a samskar or sacrament as in the case of Hindu marriage. But general belief that it's a pure and simple contract and no religious or social solemnity attached to Muslim marriage is not at all correct. It's only the form of marriage in Muslim law that is contractual and not ceremonial. And marriage itself as a concept is not merely a contract. It's of course a religious right. It's a wajib. It's a duty of a Muslim. And it's a sunnah. It's a way of the Prophet. Prophet പറഞ്ഞിട്ടുണ്ട് ഈ കല്യാണം കഴിച്ചാൽ എൻ്റെ കൂട്ടത്തിൽ പെട്ടതല്ല. വേറെ സ്ഥലത്ത് പ്രോഫറ്റ് പറയുന്നുണ്ട്, പകുതി കല്യാണം കഴിച്ചാൽ മാത്രമേ ഒരു മുഴുവൻ മനുഷ്യനാവുന്നുള്ളൂ. So it's a devotion, it's a duty to follow the way of the Prophet, but it should be in the form of the contract. There are certain decisions which says that Muslim marriage is purely a contract, not correct. So marriage under Muslim law is a solemn pact between a man and woman, soliciting each other's life companionship, and which in law takes the form of a contract. So you can define the terms of the marriage in the Nikah Nama. When I deal with Talaq al-Tafweez, I'll come to that. You can enter into the contract that even though polygamy is permitted, at the time of entering into the contract, since it's Legal form is a contract. You can enter into a contract that he shall not contract another marriage without his consent, without her consent. Unlike Pakistan, to have a second marriage, the consent of the first wife is not necessary in India. Pakistan it is. But you can enter into a contract here that without her consent, he shall not enter into second marriage. That is a valid contract. And he can also enter into a contract that he shall not have a second marriage at all. Of course, such a type of contract should not oppose to public policy. That's all. It's also polygamy. The polygamy, the under Muslim personal law as well as under true Sharia. The personal law is not true Sharia. Sharia is what the law that is embodied in the Holy Quran. But personal law now we follow is the mixture of the original Sharia, the Sunnah, Ijtima, and various precedents, customs, practice, etc. The original Sharia as well as in the Muslim personal law now we follow, male can have as many as 4 wives at a time. It is permissible. But the general belief that without any restriction, a male can have as many as 4 wives is not at all correct. The Holy Quran as well as the Muslim personal says the second marriage is permitted only under exceptional circumstances. And second marriage is permitted only if you are sure that you can treat both or more than one wife at a time in all respects. There is a verse in the Quran that if you feel that you can't treat both wives equally, you shall not marry second time. Thus the polygamy in Muslim law is not a rule but only an exception. The constitutional validity of polygamy was challenged in the celebrated decision Naraswapa Malik. Bombay Justice Kaplan's decision, very beautiful decision on this one, and it also deals with whether personal law is amenable to the constitution. Where it was held that polygamy for males and monogamy for female do not discriminate against women on the ground of sex only and accordingly not validity of so many cultural aspects which are being discussed. And Kerala High Court, those who are interested, the young lawyers, they can take down these citations on polygamy. The Kerala High Court in 2 cases has held that the polygamy is permitted only under exceptional circumstances. See, in so many countries, regulations have been made in contracting the second marriage. In Algeria, the intended second marriage must be justified and must be able to treat co-wives equally. I don't know how is it possible. And consent of existing and intended wife necessary. That is in Algeria. Indonesia, Iraq, Malaysia, Philippines, Somalia, etc. must obtain prior permission of the court. Pakistan, Bangladesh, prior permission from Qasi, judicial body is necessary. And also in Pakistan, the permission of the first wife is necessary. In Indonesia, Somalia and South Yemen, the court can allow a bigamous marriage only if the first wife is suffering from barrenness, a physical defect or an incurable disease. Also if she fails to act as a wife. In Indonesia or has been imprisoned. Okay, 2 years in South Yemen. See, the verse, the polygamy permitted verse Quran നോക്കിയാൽ നമുക്ക് കാണും ഒരു യുദ്ധത്തിന് ശേഷം ഒരു പ്രദേശത്ത് മുഴുവൻ ഒരുപാട് സ്ത്രീകളും കുറച്ച് പുരുഷന്മാരും ഉണ്ടായിരുന്ന ഒരു സാഹചര്യത്തിലാണ് ഇത് പെർമിറ്റ് ചെയ്യുന്നത്. ഇറ്റ് ഷോസ് ദാറ്റ് ഓൺലി അണ്ടർ എക്സെപ്ഷണൽ സർക്കംസ്റ്റാൻസസ് ഇറ്റ് ഈസ് പെർമിറ്റഡ്. അതേപോലുള്ള സമാനമായ എക്സെപ്ഷണൽ സർക്കംസ്റ്റാൻസസ് മാത്രമേ പറ്റുള്ളൂ. And India, Bangladesh and Pakistan failure to treat co-wives equally is a ground for divorce. If you look at 1939 Act, you will find it. In Tunisia and Turkey, polygamy is totally prohibited. Yet another feature of Muslim marriage is mahar. See, it is an essential ingredient of Muslim personal law. It is, this concept of mahar also is widely misunderstood. If you look at a well-known judge, a celebrated judgment of the Apex Court written by Justice Krishna Iyer, I think first little Baita Hara versus Ali Hussain. Even Justice V.R. Krishna Iyer regarded mahar as a sum payable under customary or personal on divorce, a sum payable on divorce. That was corrected by Justice V.R. Krishna Iyer himself later on in the famous Shabanus case. There is some believe that it is consideration, and others believe that it is a dowry. Yet another people believe, as Justice Krishna Iyer wrote in Vaitara, that it is something payable on divorce. But the mahar is neither a consideration nor a dowry. It is given to the wife at the time of marriage as a token of her respect. And the true concept of mahar has been explained in AR 1980 SC 173, so you will find it here. It's not a consideration, it's not dowry, nor is it a sum payable on divorce. In fact, it is given at the time of marriage as a token of respect of the wife. This is the true definition of mahar. I will come to divorce.
10 more minutes.
10 more minutes. I will just rush through. See, under Muslim personal law, predominant is uncodified. It permits out of court divorce, extrajudicial divorce both to man and woman. And divorce through court at the instance of the wife, and divorce by mutual consent are two extrajudicial. The extrajudicial wife and extrajudicial divorce allowed to the husband is talaq. You know that triple talaq has been declared as a constitutional by the Apex Court in Sharaban's case. There is a widespread belief that a Muslim law of divorce, talaq, is one-sided, arbitrary and discriminatory towards women. And it gives unlimited power to the husband to divorce his wife at any time without assigning a result at all. But it's not so. That if you look at even the Quranic provisions in the true Sharia law, it's specific that there should be reasonable cause, can only be resorted as a last resort after all consideration processes are failed. In fact, in Muslim law, marriage is the rule of life and divorce is only an exception, not vice versa. It also, but at the same time, it also exiles the modern breakdown theory of divorce. The Sharia prescribes 4 steps before pronouncement of talaq. 1. When there is marital discord, the husband has to first reason the wife through discussion, mutual discussion. ആദ്യം പ്രശ്നം ഉണ്ടെങ്കിൽ സംസാരിച്ച് പരിഹരിക്കാൻ നോക്കുക. 2. If differences persist, then the parties are asked to sexually distance themselves from each other with the hope that the temporary physical separation may encourage them to unite. This is the second step. Even if this fails, the husband is instructed as a third step to once again explain to his wife the seriousness of the situation, trying to bring about a reconciliation. Here the husband must explain to his wife that if they do not resolve their differences soon enough, their dispute may go beyond the confines of their house and become common knowledge. Even after the third step, the dispute still remains unsolved. As a fourth step, the matter is to be placed before two arbitrators, one for the family of each spouse for resolution. The first, they have to discuss each other, and second, the sexual decision. Third, once again, the husband has to convince the wife that if they do not resolve their dispute, still it's going to be it may go beyond the confines of the house, and for the dispute still persists, they have to try for an amicable settlement through arbitrators. See, this concept of arbitration has been introduced in all the statutory personal sector of various other communities very recently, after 1955. And after the failure of these 4 attempts, still the law does not permit to pronounce talaq at courts. After the failure of all this, after the failure of these 3 attempts, and after the failure of the 4th attempt of arbitration, still if the dispute persists, the husband is free to pronounce talaq. But that pronouncement of talaq does not ipso facto resolve the marital tie. This talaq has to be pronounced when, during the period called tuhur, when the wife is in menstrual free period. And thereafter, he has to wait the period of iddah. Period of iddah means in the case of pregnant wife, the period till she is free from confinement, and in respect of all other wives, approximately 3 months, during which at least 2 menses free period of the wife would have been free. This is 3 months period. The idea being to afford the man a fair chance or several chances to grow close to the wife and in all probability reconsider decision. After this 3 months iddah period, still the husband is convinced that there is no possibility for reunion, then the talaq takes place. This is the law. There are two modes on talaq, ahasan and talaq hasan. ഈ ആദ്യത്തെ 4 സ്റ്റെപ്സ് എല്ലാം രണ്ടിലും വേണം. ഈ 4 സ്റ്റെപ്സ് കഴിഞ്ഞ് റീകൺസിലേഷനും ആർബിട്രേഷനും ഒക്കെ കഴിഞ്ഞിട്ട് ഐദർ യു ക്യാൻ പ്രൊനൗൺസ് തലാഖ് അപ്പോൾ പറയുക, പറഞ്ഞു കഴിഞ്ഞാൽ തന്നെ ഇറ്റ് ഇസ് അപ്പോൾ പ്രാബല്യത്തിൽ വരുന്നില്ല, റീകൺസിഡർ ചെയ്തിട്ട് റിവോക്ക് ചെയ്യാൻ പറ്റില്ല. See, during this period, express revocation avashyamilla. If there is sexual intercourse, it has to be treated as revocation. Then entire process, period change process being done. First is, പറയാം 3 months wait ചെയ്യാം, 3 months കഴിഞ്ഞിട്ട് talaq will come into force. There is another code, it is also acceptable. Each, പിന്നെ tuhar period ഉണ്ടല്ലോ, 3 months period, each menstruation free period ഓരോ തലാഖ്, അതാണ് 3, 1 ജോലി, 2 ജോലി, 3 ജോലി എന്ന് പറയും. ആ പറഞ്ഞിട്ട് ദെൻ ഇദ്ദ പീരീഡ് കഴിഞ്ഞുള്ള ഫൈനൽ തലാഖ് പറയും, അത് റിവോക്ക് ആവും. ദാറ്റ് ഇസ് ദ ഡിഫറൻസ് ബിറ്റ്വീൻ തലാഖ് അഹാസൻ ആൻഡ് ഷോർട്ടേജ് ഓഫ് ടൈം. ഐ ആം നോട്ട് എക്സ്പ്ലെയിനിങ് മച്ച്, ദാറ്റ്സ് ഇറ്റ്. എൻ്റെ ഡിസിഷൻ ഉണ്ട്, അത് ഇറ്റ്സ് വെരി ഡീറ്റെയിൽഡ് ഡിസിഷൻ, മൈ ജഡ്ജ്മെന്റ് യു ക്യാൻ ഗോ. അത് ജാഫർ സാദ് വേഴ്സസ് മാർവ 2022 KLT 659 ഡീറ്റെയിൽ ആയിട്ട് പറഞ്ഞു. ഓക്കെ, so this is in fact talaq എന്ന് പറയുന്നത് ഒരു വളരെ റീസൺ വേണം. ആ റീസൺ ഉണ്ടാക്കാൻ ആദ്യം കൺസിലേഷൻ പ്രോസസ് വേണം. 4 സ്റ്റെപ്സ് കഴിഞ്ഞിട്ട് വളരെ എല്ലാ സാവകാശം കൊടുത്തിട്ട് when it is convinced that there is no other good than, പിന്നെയും അത് മുന്നോട്ട് കൊണ്ടുവന്ന അർത്ഥത്തിൽ ഉറപ്പാക്കാൻ മാത്രമേ ചെല്ലാൻ പാടുള്ളൂ. ബട്ട് in practice it was otherwise. Of course, even if you look at Shahrabanu's case, even a minority judgment by Justice Kahar and Justice Nazir, അവർ ബ്യൂട്ടിഫുള്ളി ഡിസ്ക്രൈബ് ചെയ്യുന്നുണ്ട് ഇന്ത്യയിൽ. പക്ഷെ ഇങ്ങനെയല്ല നടന്നു വരുന്നത്. തലാഖ് അറ്റ് എ ഗോ ഒരുമിച്ച് ചൊല്ലുന്ന, ആൻഡ് ദാറ്റ് ഈസ് റെക്കഗ്നൈസ്ഡ് ആൻഡ് ആക്സെപ്റ്റഡ്, ആൻഡ് ദേ ആർ ഇൻ ഫേവർ ഓഫ് ആക്സെപ്റ്റിംഗ് ഇറ്റ്. മൈനോറിറ്റി ജഡ്ജ് ബ്യൂട്ടിഫുള്ളി റിട്ടൺ. ഇന്ത്യയിൽ എത്രയോ വർഷങ്ങളായിട്ട് ഇതാണ് നടന്നു വരുന്നത്. ദാറ്റ് ഹാസ് ബിക്കം ദ ലോ എന്ന് ആ ജഡ്ജ്മെന്റ് വായിച്ചു വെക്കണം. പക്ഷെ നേരെ തിരിച്ചിട്ടാണ് ഇത്ര കാലം നടന്നത്. ദാറ്റ് ഇസ് കോൾഡ് തലാഖ് ബിത്ത്, ദാറ്റ് ഇസ് ട്രിപ്പിൾ തലാഖ്. എന്താ പറഞ്ഞു കഴിഞ്ഞാൽ പെട്ടെന്ന് തന്നെ ഒന്നും വേണം, ഈ ഒരു പ്രോസസ്സും ഇല്ല, ഒരു സുപ്രഭാതത്തിൽ തലാഖ് ബൈ SMS, ഇറ്റ്സ് ഓൾ ഡിക്ലെയർഡ് ആസ് വാലിഡ്. യു റീഡ് മൈ ബുക്ക്, അതിൽ പറയുന്നുണ്ട് ഇതേപോലെ കുറേ ഇൻസ്റ്റൻസസ്. ഫോൺ വിളിച്ചിട്ട് പറയുന്നത്, ഇൻടോക്സിക്കേറ്റ് ചെയ്തിട്ട് പറയുന്നത്, ബോധമില്ലാതെ പറയുന്നത്, തമാശക്ക് പറയുന്നത്, ഇതൊക്കെ ഇറ്റ്സ് റെക്കഗ്നൈസ്ഡ് ബൈ ഉലമാസ്. ഈ കങ്കാരു കോട്ട്സ് ഉണ്ടല്ലോ പല സ്ഥലങ്ങളിൽ, ദേ ഹാവ് accepted. So this is in practice മുഴുവൻ പോകുന്നത് ഈ ഫോളോ ചെയ്യുന്ന വരുന്ന തലാഖിൽ വാട്ട് യു കോൾ ട്രിപ്പിൾ തലാഖ്. ഒന്നുമില്ലാതെ ഈ റീകൺസിലേഷൻ പ്രോസസ് ഒരു കാരണമില്ലാതെ ഓൺ എ ഫൈൻ മോർണിംഗ് മൊഴി ചെല്ലുക. ദിസ് ഇസ് തലാഖ് ബിത്ത്, ദാറ്റ് ഇസ് കോൾഡ് ട്രിപ്പിൾ. That has been now declared as unconstitutional by the Supreme Court in Sharaban's case. Okay, 2017-9 SCC1. It's a very interesting case. Those who are interested in personal law must read it. There, so many questions arose. An incident question that arose was whether whether personal law is Muslim personal law is amenable to the Constitution. See, for a long it is a debatable issue whether personal law is law under Article 13 of the Constitution and thus amenable to the Constitution. See, there is no doubt that codified personal laws is amenable to the Constitution because it falls within Article 13. That is why the personal laws of all personal laws of Hindus, Christians, etc., and even certain codified laws of the Muslims, like 1939 Act 1986, are amenable to the Constitution. It can be declared as unconstitutional if it violates Part 3 of the Constitution. But the question whether the uncodified personal law is amenable to the Constitution. Narazu Appamali's case right from 1959. The court took the view that it's not the law under Article 13, thus not amenable to the Constitution. So it cannot be declared, uncodified personal laws cannot be declared as unconstitutional, being violative of Part 3 of the Constitution. That is the law. That is being followed. There in the state of Bombay versus Narazu Appamali, and the Supreme Court in Krishna Singh versus Madura High, the Supreme Court has also said so. And Matthew versus Union of India also said so. But this issue came up for consideration before the Supreme Court in Sharabanu's case. Because until and unless it is held that the personal laws, unqualified personal laws is amenable to the Constitution, the triple talaq cannot be declared as a Constitution. But in Sharabanu's case, two judges, that is majority Justice Nariman and Justice Lalit, I think. Justice Nariman and Lalit, I'm not sure. Justice Nariman and Justice Lalit said that personal laws are amenable to the Constitution. And minority judgment Justice Kahar and Justice Nazir and that personal laws are not amenable to Constitution. But Justice Kurian Joseph took the view. He did not answer this point whether personal laws are amenable to Constitution or not. Justice Kurian Joseph took the view that triple talaq is against Holy Quran, the main source of the Muslim personal law, and thus has to be declared as void. So 2:2, plus with the aid of Justice Kurian Joseph, this finding ultimately was declared as unconstitutional. This is what happened. Still, the basic question that whether personal laws are amenable to the constitution was not answered. But the majority view consisting of, out of the majority, 3 judges, Justice Nariman and Justice Lalith, took the view that Muslim personal law is a state action because as per 1937 Act, it has been statutorily recognized. So it has to be treated as a state action, thus amenable to the Constitution. It does not answer that personal laws are amenable to the Constitution. So now the polygamy is under challenge before the Supreme Court. The inheritance law under 2:1 also is under challenge before the Supreme Court. The under variable, this decision cannot be taken as an aid to contend that Muslim personal laws are amenable to the Constitution. This is the interesting aspect I incidentally referred to. Please read it. So this is now the law is that only triple talaq is declared as unconstitutional, and the talaq following the principles of Sharia law that I have already said, following these 4 steps, it is still valid. Then I'll just keep so many countries as anyway. Then Kula. See, till recently, till the division bench of Kerala High Court held recent Justice Mustaq and Justice Dias, nobody knew that a similar power that is available to male is available to female as well. Nobody knew. But it is there, the Quran itself. The very same power that is available to the male to recourse to extrajudicial divorce is there to the female as well. Same power. She need not go to the court. But see, it's a concept of family under Islam is that if there is any matter dispute, that dispute you need not drag into a court. It has to be resolved in the 4 corners of your house. And you try all attempts. If you can resolve the issue within yourself, break it up. That is the concept. After all attempt of reconstruction, നിങ്ങൾ ഇതൊന്നും ഒരു വിധത്തിലും ഒരുമിച്ച് പോകാൻ പറ്റില്ലെന്ന് ബോധ്യപ്പെട്ടാൽ സന്തോഷപൂർവ്വം പാരിതോഷികം നൽകി വിട്ടയക്കുക എന്നാണ് പറയുന്നത്. അത് കഴിഞ്ഞാൽ നിങ്ങൾ സന്തോഷപൂർവ്വം പിരിക്കും, അല്ലാതെ വെറുതെ കോടതിയിലേക്ക് വലിച്ച് നീട്ടണ്ട എന്നാണ് കോൺസെപ്റ്റ്. അതുകൊണ്ടാണ് സിമിലർ പവർ ഇസ് ഗിവൺ ടു ദ ഫീമെയിൽ ആസ് വെൽ. ഹസ്ബൻഡ് എന്ത് പവറോ സെയിം പവർ ഫീമെയിൽ, ദാറ്റ് ഇസ് കോൾഡ് കുല. ആ കുലയിലുള്ള 2 ഒരേ ഒരു ഇതെന്ന് പറഞ്ഞാൽ ഞാൻ നേരത്തെ പറഞ്ഞ മെഹർ ഉണ്ടല്ലോ, മെഹർ ഇസ് ദാറ്റ് യു ഹാവ് ടു ഗിവ് ഇറ്റ് ബാക്ക്, ദാറ്റ്സ് ഓൾ. ഓർ അറ്റ്ലീസ്റ്റ് യു ഹാവ് ടു മേക്ക് ആൻ ഓഫർ, ദാറ്റ്സ് ഓൾ. ഈ റീകൺസിലേഷനും മറ്റൊക്കെ അതിൽ വേണം, എല്ലാത്തിലും വേണം. യു ഹാവ് ടു ഗിവ് ഇറ്റ് ബാക്ക്. കൊടുത്തില്ലെങ്കിൽ അത് ഇൻവാലിഡ് ആണെന്ന് ആകാൻ പോകുന്നില്ല. ഇറ്റ് ഈസ് എ ഡെപ്റ്റ്, ദാറ്റ്സ് ഓൾ. സോ ദാറ്റ് ഇസ് right equal to talaq, right? There, Justice Mustaq's judgment exposes sex. 2021 2 cases 709, and our judgment following that SB versus Ash. Okay. That judgment just exposes sex, deals with the details of Kula, and there was a early judgment in 1972 KLT 785 Justice V. Khalid, which stood till it was overruled in X versus X. There was a finding that Muslim woman cannot dissolve her marriage before the provisions of the Dissolution of Muslim Marriage Act 1939. You know that 1939 gives power to gives right to the Muslim woman to approve the court and to get divorce on specific grounds. This decision says that Muslim woman can get divorce only under this act. That was overruled in division bench by the division bench, and held that Muslim woman has power, extrajudicial power as well by way of Kula. Okay. Then next is Talaq al-Tafwis. It is yet another mode of divorce available to the wife. At the time of marriage, the parties can enter into contracts. The legal form is contract, what you call nikah. You can lay down conditions in the nikah. And suppose there's a clause has been entered in nikah that in case the husband contracts another marriage, he is entitled for divorce. For any such case where he doesn't maintain her, he is entitled for divorce. It is enforceable. It's a delegated divorce that if conditions are prescribed in the nikah on happening of that condition, you can seek divorce. That is what talaq is. It's an extra right available to the wife. And next one is mubarak. This is also extrajudicial divorce, but it is divorce by mutual consent. Right. Okay. Finish 1 minute. Divorce by mutual consent. A difference in the other personal laws and in the Muslim law is that under the Muslim law, by way of mubarak, you need not go to the court. You need not wait cooling period. Nothing. But simply draw an agreement, sign it, that is sent out. Mubarak. I'll finish. See, these extrajudicial divorces, talaq, khula, mubarak, etc. All these do not have a seal of the court. But in പലപ്പോഴും ഫോറിൻ കൺട്രിയും മറ്റൊന്നും ഈ ഒരു മുബാറക് അഗ്രിമെന്റോ അല്ല ജസ്റ്റ് കുല പ്രൊണൗൺസ് ചെയ്യുന്ന ആക്സെപ്റ്റ് ചെയ്യാൻ പോകുന്നില്ല. സോ വി ഫൗണ്ട് ഇറ്റ് വെരി പ്രാക്ടിക്കൽ ഡിഫിക്കൽട്ടി. സോ the decision, there is a decision with decision, myself and Mustaq, which says that if you pronounce, if you exercise extrajudicial power of divorce, either by way of talaq, khula or mubarak, you can get it endorsed in a court. You approach family court, procedure is prescribed, simply go there, issue notice to the party within 1 month or 2 months, you will get the seal of the court also. This court. So, and finished. Half minute. There is another mode that is called FUSC. The FUSC is what 1939 Act is. നമ്മൾ പത്രത്തിൽ പഴക്കം പരസ്യമാണ് ഞാൻ ഫസ്ക് ചെയ്യുന്നു എന്ന് പറഞ്ഞു. സ്ട്രോങ്. അത് ശരിക്കും പറഞ്ഞാൽ കുലയുടെ വേറൊരു ഫോമാണ്. ഫസ്ക് ഇസ് divorce through court. It's an extra power given to, right given to Muslim wife. She can, instead of exercising the power of extrajudicial divorce, she can also approach the court. നേരത്തെ കാസി ആയിരുന്നു, that is statute recognized in 1939, and you can approach the court. This is the first. So talaq, khula, mubarak and FUSC. These are the 4 modes available. I stop here. Time is up. Thank you. If there is any doubt, I will clarify. Thank you very much for patience.
Thank you, sir. Thank you very much for your valuable insight.